Karen told me to stop talking. I'm the Chief Justice reviewing her appeal. The transition from a respected justice of the state Supreme Court to the newly appointed Chief Justice had been a whirlwind. One moment, I was immersed in the intricate details of legal briefs and appellate arguments. And the next, I was navigating the administrative complexities of the highest court in the state. While I embraced the profound responsibility and the opportunity to shape the future of our legal landscape, I also cherished the moments when I could simply be Alex, the person who enjoyed a quiet afternoon with a good book or a thoughtful conversation without the weight of my professional title preceding me. I've always been a private person. Even before the robes and the Your Honor, I preferred a degree of anonymity in my day-to-day life. The constant scrutiny that came with public service was something I tolerated out of a sense of duty, but it wasn't something I actively sought. My weekends were sacred, a time for long walks in the nearby nature preserve, exploring the diverse culinary scene our city had to offer, and catching up with friends who knew me simply as Alex, not as a figure of judicial authority. One particularly sunny Saturday afternoon, I decided to visit a charming little bookstore tucked away on a quiet side street. I'd been meaning to pick up a newly released biography of a legal pioneer, and the promise of a strong cup of coffee from their in-house cafe was equally enticing. Settling into a comfortable corner armchair, the scent of old paper and brewing beans a comforting aroma, I took a call I'd been meaning to return, a discussion with a fellow legal scholar about a particularly nuanced aspect of an upcoming appeal before the court. The case involved a complex dispute over intellectual property rights and held significant implications for the burgeoning tech industry in our state. I spoke in a low, measured tone, mindful of the other patrons browsing the shelves or enjoying their own quiet moments. I was deeply engrossed in the intricacies of the legal arguments, my mind dissecting precedents and exploring potential interpretations of the relevant statutes. The gentle rustling of pages and the soft murmur of conversations faded into the background as I focused on the intellectual puzzle at hand. Suddenly, a voice sharp and laced with an unmistakable air of entitlement sliced through my concentration. Excuse me, are you even aware that other people are trying to enjoy some peace and quiet here? Your loud talking is incredibly disruptive." My brow furrowed almost imperceptibly. I paused my conversation, a fleeting moment of annoyance interrupting my train of thought. The voice, laced with self-importance, was directed squarely at me. I glanced up to see the source of the interruption. Standing a few feet away, near a display of bestsellers, was a woman who seemed to have materialized straight from the pages of an internet meme. Her impeccably styled blonde hair, the oversized designer sunglasses perched on her nose even indoors, and the rigid posture all screamed a certain archetype. She clutched a small, yappy dog in a ridiculously ornate carrier and radiated an aura of being perpetually inconvenienced by the mere existence of others. The woman, whom my internal classification system immediately identified as a textbook Homeowners Association Karen, was glaring directly at me, her lips pursed in an expression of profound disapproval. Several other bookstore patrons had subtly turned to observe the unfolding drama, a mixture of awkwardness and a shared sense of, "Oh, here we go." Despite the blatant rudeness, I maintained my composure. Years of presiding over contentious courtroom proceedings had instilled in me a certain unflappability. I offered the woman a polite but neutral glance and then turned slightly away, intending to continue my call. However, HOA Karen was clearly not one to be easily dismissed. Her voice rose in volume, drawing more attention from the other book lovers. I said, "Do you mind? Some of us actually come here to read and think, not to listen to your endless prattling about whatever it is you're going on about. Have some consideration for others." I suppressed a sigh. The irony of being told to be quiet while discussing the very principles of intellectual property law in a hushed bookstore was almost darkly amusing. I lowered my phone slightly and addressed the woman again, my voice calm but carrying the quiet authority that commanded attention in my courtroom. "I apologize if my conversation is disturbing you," I said, my tone even and measured. "I assure you, it is a private and important call." "Important or not," HOA Karen retorted, her voice dripping with indignation, "you should still be mindful of your surroundings. This isn't your personal phone booth. Some of us have a right to a tranquil browsing experience." My patience, usually a deep reservoir, began to feel a slight ripple. This woman had absolutely no idea who she was addressing or the significance of the discussion she was so vehemently trying to shut down. "I am nearly finished," I stated, my tone still polite but with an underlying firmness. I raised my phone back to my ear. "Dr. Ramirez," as I was explaining, HOA Karen, however, was determined to have the last word. She huffed loudly, her arms crossed over her chest, her glare laser-focused on me. Honestly, the lack of common courtesy these days is appalling. Some people just have no self-awareness. She then turned and marched towards the cashier, her yappy dog adding a series of indignant yips to her dramatic exit. I shook my head almost imperceptibly, a wry smile playing on my lips. The encounter was certainly memorable. I finished my call with Dr. Ramirez, the earlier flow of our discussion slightly disrupted by the unexpected interruption. I made a mental note of the woman's distinctive appearance, the rigid blonde hair, the oversized sunglasses, the perpetually offended air, an unfortunate reminder of the entitlement some individuals seem to wear like an invisible crown. Weeks later, I found myself deeply immersed in the preliminary review of cases scheduled for the upcoming Supreme Court session. One particular appeal caught my attention: a contentious dispute involving a local homeowners association and a resident who had been found in violation of numerous community bylaws related to property maintenance and landscaping. The name of the appellant was Karen Miller. As I delved into the details of the case, the familiar contours of such disputes, the seemingly minor infractions escalating into major legal battles, the unwavering belief in the righteousness of one's own interpretation of the rules, began to resonate with a faint, almost subconscious familiarity. Then, as I reviewed the initial filings and the transcripts from the lower court proceedings, a specific detail leaped out at me. The lead representative for the Willow Creek Estates Homeowners Association in the original dispute was listed as Karen Miller. The rigid blonde hair, the air of unwavering self-assurance, the conviction in her own perspective, the image of the woman in the bookstore flashed through my mind with a sudden, sharp clarity. A wave of almost surreal irony washed over me. Could it possibly be the same Karen Miller? The odds seemed astronomically low, yet the distinct impression the woman had made was undeniable. As I continued to review the case materials, a growing sense of morbid curiosity began to stir within me. The woman who had so rudely told me to stop talking in a public place was now seeking the highest court in the state to overturn a lower court's ruling against her. And I, Alex, the person she had so dismissively silenced, was now the Chief Justice who would be presiding over her appeal. The stage was set for a courtroom drama infused with a uniquely personal and undeniably ironic twist. As Chief Justice, Alex meticulously reviewed the lower court records of Miller v. Willow Creek Estates Homeowners Association, the details of Karen Miller's legal saga unfolded like a particularly contentious neighborhood dispute magnified under a legal microscope. The core of the issue revolved around a series of alleged violations of the Willow Creek Estate's meticulously detailed and, frankly, somewhat draconian bylaws. These ranged from the precise shade of beige Karen had chosen for her exterior trim, a hue deemed inharmonious with the community's unified aesthetic vision, to the height of her birdbath, a mere 2 inches above the maximum allowed, and the unauthorized placement of a decorative ceramic frog on her porch railing. The transcripts of the initial hearings painted a vivid picture of Karen's unwavering stance. She argued, often with considerable volume and dramatic flair, that the HOA's enforcement of these seemingly trivial rules was nothing short of tyrannical overreach, a personal vendetta orchestrated by a few power-hungry board members who simply didn't like her. Her testimony was a whirlwind of indignant pronouncements about her rights as a property owner, her artistic sensibilities being stifled, and the sheer absurdity of the HOA's preoccupation with such minor details. The lower court judge, a patient but increasingly weary man named Judge Thompson, had listened to hours of testimony, reviewed countless photographs of beige paint swatches and ceramic amphibians, and ultimately ruled decisively in favor of the Willow Creek Estates HOA. His written opinion cited the legally binding nature of the community's bylaws, the democratic process by which they were established, and Karen's consistent and willful disregard for these regulations. He also noted her belligerent and uncooperative demeanor throughout the proceedings, suggesting that a more amenable approach might have yielded a different outcome. Undeterred by this resounding defeat, Karen had launched an appeal to the State Court of Appeals. Her arguments remained largely the same: that the HOA's rules were petty and unreasonable, that their enforcement was discriminatory, and that her fundamental rights as a homeowner were being trampled upon by a bunch of control freaks obsessed with beige and birdbath heights. The Court of Appeals, after a perfunctory review of the lower court's findings and the applicable law, summarily affirmed Judge Thompson's ruling, finding no substantive legal errors in his judgment. Now, Karen Miller's last hope rested with the state Supreme Court. Her petition for review, drafted by a junior associate at a local law firm who likely regretted drawing the short straw in this particular case, argued that the matter raised significant issues of statewide importance regarding the scope and limitations of homeowners' association power, issues that warranted the Supreme Court's definitive guidance. It was this petition that had landed on my desk, amidst a pile of far more compelling legal quandaries. As I delved deeper into the convoluted details of the beige gate and the froggy faux pas, I couldn't help but see the echoes of the woman in the bookstore. The same unwavering conviction in her own perspective, the same dismissive attitude towards anyone who dared to disagree with her, the same dramatic flair in presenting even the most mundane grievances. It was all there, meticulously transcribed in the dry language of legal proceedings. Meanwhile, Karen Miller continued her reign in Willow Creek Estates, seemingly oblivious to the identity of the Chief Justice, who would be scrutinizing the minutiae of her landscaping choices. Her interactions with her neighbors remained, by all accounts, a masterclass in self-righteous indignation. She continued to issue pronouncements on everything from the proper way to prune hydrangeas to the acceptable volume level for weekend barbecues. Her pronouncements often punctuated by pointed glances at those she deemed to be in violation of her self-proclaimed standards. She maintained frequent contact with her long-suffering lawyer, a young man named Mr. Davies, who sounded increasingly weary in his written communications. Karen remained convinced that the Supreme Court, once they grasped the sheer injustice of her situation, would undoubtedly rule in her favor. Her conversations with Mr. Davies were less about legal strategy and more about venting her frustrations and reiterating her unwavering belief in her own righteousness. As the date for the Supreme Court's decision on which appeals they would grant review approached, Karen's optimism bordered on delusional. She envisioned a triumphant victory, a stern rebuke for the petty tyrants of the Willow Creek Estates HOA, and a personal vindication that would solidify her status as a champion of homeowner rights, at least her interpretation of those rights. She regaled her neighbors with increasingly elaborate tales of her impending legal triumph, painting herself as a brave David, standing up against the Goliath of suburban bureaucracy. Unbeknownst to Karen, I had circulated the details of Miller v. Willow Creek Estates among the other justices. While the specifics of beige paint and ceramic frogs seemed almost comical, the underlying legal questions about the balance of power within private communities and the extent to which individual aesthetic choices could be regulated did touch upon broader legal principles. The justices engaged in a preliminary discussion, with Justice Chen expressing amusement at the sheer pettiness of the dispute, while Justice Sotomayor raised concerns about the potential for HOAs to become overly intrusive. Throughout these internal deliberations, I remained outwardly neutral. I did not disclose my prior, albeit brief, encounter with Karen, adhering strictly to the ethical guidelines that govern judicial conduct. My assessment of the case was based solely on the legal arguments presented in the briefs and the rulings of the lower courts. However, I couldn't shake the distinct feeling that the Karen Miller depicted in the legal documents and the Karen Miller who had so rudely interrupted my phone call were two sides of the same remarkably entitled coin. Ultimately, after much deliberation and a few wry jokes exchanged about the fascinating world of suburban bylaws, the Supreme Court voted to grant review in Miller v. Willow Creek Estates. While the legal issues might have seemed minor on the surface, there was a general consensus among the justices that the case presented an opportunity to provide clarity on the evolving legal landscape of community associations. The notification that her appeal had been granted was met with unrestrained jubilation by Karen. She saw it as divine intervention, a clear sign that the highest court in the state recognized the egregious injustice she had suffered. She practically threw a small, self-congratulatory party, regaling a few long-suffering neighbors with tales of her impending victory and the comeuppance that awaited the HOA board. Mr. Davies, Karen's lawyer, adopted a far more cautious stance. While acknowledging that the granting of review was a positive step, he tried to temper Karen's expectations, gently reminding her that the Supreme Court agreeing to hear a case was no guarantee of a favorable outcome. He began the arduous process of preparing the appellate briefs, bracing himself for further impassioned dictation sessions with his stubbornly convinced client. As Mr. Davies toiled over the legal arguments, attempting to inject some semblance of legal reasoning into Karen's emotional tirades, I and my fellow justices began our own deep dive into the case. We meticulously reviewed the lower court records, the appellate briefs from both sides, and the relevant state statutes and precedents governing homeowners associations. The contrast between the HOA's dry, legalistic arguments and Karen's impassioned, often legally dubious claims was stark. The stage was set for the oral arguments, the moment when Karen's battle would reach its ultimate crescendo, completely unaware that one of the 9 justices who would be listening intently held a very specific and rather unflattering memory of their prior interaction. The day of oral arguments in Miller v. Willow Creek Estates Homeowners Association dawned bright and clear, a stark contrast to the simmering tension that permeated the ornate hearing room of the state Supreme Court. Karen Miller, having meticulously prepared her attire, a power suit in a shade she believed exuded assertive yet reasonable, sat at the appellant's table beside her lawyer, Mr. Davies. She exuded an air of nervous anticipation, her gaze sweeping across the imposing bench where the 9 justices would soon preside. She was ready to finally have her voice heard by the highest court in the state, confident that they would recognize the blatant injustice she had endured over beige paint and ceramic amphibians. The hushed reverence of the courtroom fell silent as the side door opened and the 9 justices filed in, their black robes rustling softly. As Chief Justice Alex took their seat in the center of the bench, their eyes briefly met Karen's. I offered the same neutral, professional gaze I extended to all parties before the court, giving no indication of our prior, less formal encounter. Karen, for her part, showed absolutely no sign of recognition. Her focus was entirely on the imposing figures before her, the arbiters of her suburban saga. The proceedings commenced with Mr. Davies presenting his arguments on behalf of Karen. He attempted to elevate the seemingly trivial dispute to a matter of broader legal principle, arguing that the Willow Creek Estates HOA had overstepped its bounds, infringing upon Karen's fundamental rights as a homeowner to express her personal aesthetic and enjoy her property without undue interference. He spoke of the slippery slope of allowing HOAs to dictate such minute details of personal taste. The justices listened attentively, their expressions inscrutable. Justice Lee posed a sharp question regarding the specific language of the community bylaws Karen had agreed to upon purchasing her home. Justice Rodriguez inquired about the precedent for judicial intervention in disputes arising from private contractual agreements. I, as Chief Justice, asked Mr. Davies to clarify the specific legal basis for his claim that the HOA's actions constituted an unconstitutional infringement. Karen sat beside Mr. Davies, occasionally leaning over to whisper emphatic agreements or to pass him notes underlined with multiple exclamation points. Her body language conveyed a sense of unwavering conviction, a palpable belief that the sheer absurdity of the HOA's regulations should be immediately apparent to the learned justices. Next, Ms. Albright, the seasoned attorney representing the Willow Creek Estates HOA, stepped to the podium. Her demeanor was calm and confident as she presented a counter-narrative, emphasizing the importance of upholding community bylaws to maintain property values and ensure a harmonious living environment for all residents. She argued that Karen had knowingly and willingly agreed to abide by these rules when she chose to live in Willow Creek Estates, and that the lower courts had correctly applied the law in upholding their enforcement. Ms. Albright deftly countered Mr. Davies' arguments, citing relevant case law that supported the authority of homeowners associations to establish and enforce reasonable aesthetic standards. She painted a picture of Karen as a consistently non-compliant homeowner who had refused to engage constructively with the HOA and had instead chosen to escalate minor disagreements into costly legal battles. The justices again engaged in rigorous questioning. Justice Kavanaugh pressed Ms. Albright on the specific criteria the HOA used to determine inharmonious paint colors. Justice Barrett inquired about the due process afforded to Karen in the enforcement proceedings. My own questions focused on the consistency of the HOA's enforcement practices across the community. As the oral arguments progressed, I found myself observing Karen with a detached professional interest that was nonetheless tinged with the memory of our bookstore encounter. The same air of unwavering self-righteousness, the same dismissive undertone when referring to those who disagreed with her. It was all subtly present in her demeanor, even in the formal setting of the Supreme Court. Then came the moment. During a particularly pointed exchange between Justice Gorsuch and Ms. Albright regarding the legal definition of unsightly in the context of decorative lawn ornaments, Karen leaned forward, her voice carrying just loud enough to be heard across the otherwise silent courtroom. "Honestly," she muttered, rolling her eyes dramatically, "some people just have absolutely no sense of aesthetics." The words, the tone, the sheer audacity of the comment in that setting. It was a near-carbon copy of her dismissive remark in the bookstore. The memory of that afternoon flooded back to me with startling clarity. The entitled woman with the helmet-like blonde hair, the oversized sunglasses perched indoors, the air of perpetual offense, rudely interrupting my private conversation about a complex legal matter. The irony was so thick it could have been cited as legal precedent. A wave of almost surreal déjà vu washed over me. The woman who had so casually dismissed my right to speak in a public place was now openly displaying the same dismissive attitude in the highest court of the state, completely oblivious to the identity of the Chief Justice, who was listening intently to her every word. I maintained my judicial composure, my expression betraying absolutely no flicker of recognition or amusement. I continued to listen to the arguments, my questions remaining sharp and focused on the legal intricacies of the case. But the personal dimension of this appeal had now reached its peak, a silent, ironic crescendo known only to me. As the oral arguments drew to a close, I addressed both counsels, my voice calm and authoritative. "The court will take this matter under advisement. We thank you for your presentations." Karen watched the 9 justices as we rose and filed back into our chambers, her expression a carefully constructed blend of hopeful anticipation and lingering indignation. She leaned towards Mr. Davies, her voice hushed but confident. "I really think we made some good points. They seem very interested in the frog issue." Mr. Davies, looking slightly less optimistic, offered a more measured reply. "They asked some challenging questions, Karen. It's difficult to gauge their leanings." Back in the relative privacy of our chambers, the 9 justices began our deliberations. The legal arguments, while centered on seemingly minor aesthetic disputes, raised fundamental questions about the balance between individual property rights and the collective interests of community associations. The discussion was lively, with Justice Kagan expressing skepticism towards the HOA's seemingly arbitrary rules, while Justice Thomas emphasized the importance of upholding contractual agreements. I listened carefully to my colleagues' perspectives, offering my own insights based on my years of experience in property law and my understanding of the delicate balance required in such community living arrangements. I stressed the need for clarity and reasonableness in HOA bylaws and the importance of fair and consistent enforcement. As the justices debated the merits of the case, the memory of my bookstore encounter with Karen remained a subtle undercurrent in my thoughts. While I was committed to rendering an impartial judgment based solely on the law, the recollection of her dismissive entitlement provided a certain context to her arguments and her general demeanor throughout the proceedings. The deliberations continued over several days, with each justice carefully weighing the legal precedents, the specific language of the Willow Creek Estates bylaws, and the arguments presented during the oral hearing. The case, while seemingly trivial on the surface, presented a genuine challenge in balancing individual freedoms with the need for community governance. Finally, the time came for the justices to cast their votes. The decision was not unanimous. Several justices sided with the HOA, emphasizing the binding nature of the community's rules. Others leaned towards Karen, highlighting the potential for HOAs to become overly intrusive and to stifle individual expression. As Chief Justice, the weight of the final decision rested heavily on my shoulders. I carefully reviewed my notes from the oral arguments, reread key passages from the briefs, and revisited relevant case law. My ruling needed to be grounded in legal principle, but I couldn't entirely divorce it from the underlying human element of the dispute. In my opinion, which I meticulously drafted, I sought to strike a balance. I acknowledge the legitimacy of homeowners associations in establishing and enforcing reasonable aesthetic standards aimed at maintaining property values and community harmony. However, I also emphasize the importance of those standards being clearly defined, objectively applied, and not based on arbitrary or purely subjective preferences. Regarding Karen Miller's specific claims, my opinion found that while the HOA had a legitimate interest in regulating exterior paint colors to maintain a cohesive aesthetic, their regulations regarding bird bath height and the placement of small decorative items on a porch railing appeared to be overly prescriptive and lacked a clear nexus to any legitimate community interest. However, my opinion also subtly addressed Karen's conduct. Without directly referencing her courtroom demeanor, I included a passage emphasizing the importance of respectful engagement and a willingness to work constructively with community associations to resolve disputes. While upholding some of her claims, the overall tone of the ruling was hardly a complete vindication of her often belligerent stance. The day the decision was released was met with a flurry of local news coverage and online commentary, most of it focusing on the seemingly absurd nature of the dispute itself. Karen Miller, however, remained blissfully unaware of the personal connection between her case and the Chief Justice, who had just ruled in part in her favor. A few days later, Karen received a copy of the Supreme Court's written opinion. As she scanned the legal jargon, her eyes glossed over much of the technical language. However, she did note the sections where the court seemed to agree with her on the bird bath and the frog. A small, self-satisfied smile played on her lips. "See," she declared to Mr. Davies over the phone. "I told you they'd see reason." Mr. Davies, sounding relieved that the ordeal was finally over, offered a cautious congratulations. He did not point out the more nuanced aspects of the ruling or the subtle critique of Karen's overall approach embedded within the Chief Justice's opinion. He simply wanted to move on. But fate, it seemed, had one final, exquisitely ironic twist in store for Karen Miller. A few weeks after the Supreme Court's ruling, a local news outlet ran a feature article on Chief Justice Alex, highlighting their recent appointment and their commitment to upholding the principles of fairness and justice. The article included a photograph of the Chief Justice, a photograph that stopped Karen Miller dead in her tracks. The sharp, intelligent eyes, the composed demeanor. It was the person from the bookstore, the person she had so rudely told to stop talking. The realization hit Karen with the force of a legal subpoena. The Chief Justice, who had just ruled on her ridiculous case about beige paint and ceramic frogs, was the very person she had so dismissively silenced in public. The full embarrassing truth finally dawned on Karen Miller, leaving her speechless and utterly mortified. The color drained from Karen Miller's face as she stared at the newspaper photograph of Chief Justice Alex. The sharp, intelligent eyes, the composed expression, they were unmistakable. The memory of her own rude and entitled behavior in the bookstore weeks ago flooded back with excruciating clarity. The woman she had so dismissively silenced, the person whose incessant prattling she had so imperiously interrupted, was the Chief Justice who had just ruled in part on her absurd legal battle over beige paint and ceramic frogs. A wave of profound and all-encompassing embarrassment washed over Karen. Her self-righteous indignation, her unwavering belief in her own victimhood, now seemed laughably pathetic in the face of this cosmic irony. The universe, it appeared, had a way of delivering justice with a side of deeply personal humiliation. The immediate aftermath of this earth-shattering realization was a period of uncharacteristic silence and introspection for Karen. The usual stream of complaints directed at her neighbors abruptly ceased. The self-congratulatory pronouncements about her partial victory in the Supreme Court vanished into thin air. She retreated into her meticulously ordered home, the newspaper featuring Chief Justice Alex lying on her perfectly polished coffee table like a stark reminder of her own monumental blunder. She reread the article multiple times, each sentence now imbued with a new, deeply personal meaning. The Chief Justice's commitment to fairness and justice, their reputation for sharp intellect and unwavering impartiality, It all underscored the sheer absurdity of Karen's earlier behavior. The thought that she had dared to silence such a figure over a private phone call in a bookstore was almost physically painful. Days turned into a week, and Karen remained uncharacteristically subdued. Her interactions with her neighbors were limited to brief, mumbled greetings. The garden gnomes remained defiantly perched on her lawn. The beige trim continued to clash, in her opinion at least, and the ceramic frog still graced her porch railing. It was as if the Supreme Court's ruling, and her subsequent mortifying realization, had somehow deflated her usual sense of self-importance. Then one crisp autumn afternoon, a week after the newspaper article had been published, Karen found herself walking with uncharacteristic purpose towards a familiar address, the home of Chief Justice Alex. The audacity of the act was not lost on her, but a strange sense of compelled humility had taken root. She had to do this. She had to attempt to make amends, however inadequate her apology might be. Standing on the sidewalk across from the Chief Justice's unassuming home, Karen hesitated for a long moment. The weight of her past behavior felt like a physical burden. Finally, taking a deep breath that did little to steady her nerves, she crossed the street and walked up the driveway. She rang the doorbell, her hand trembling slightly. The door was opened by Chief Justice Alex themselves. Their expression was calm and composed, a hint of polite inquiry in their eyes. They offered no outward sign of recognition, maintaining the same professional neutrality they had displayed in court. "Ms. Miller," I said, my voice even and measured, "what can I do for you?" Karen's carefully rehearsed words seemed to evaporate in the face of my calm presence. "Chief Justice Alex," she stammered, her face flushing crimson. I know this is highly inappropriate, but I felt compelled to apologize in person." My eyebrow rose slightly, prompting her to continue. Some weeks ago," Karen began, her voice barely above a whisper, "in a bookstore, you were on the phone, and I was incredibly rude to you. I demanded that you stop talking." A faint, almost imperceptible smile touched my lips, but my expression remained largely neutral. "I do recall the incident, Ms. Miller." Karen's shame deepened. "I had absolutely no idea who you were. And then, after the Supreme Court's ruling, I saw your photograph in the newspaper. The realization, it was deeply mortifying." Tears welled in Karen's eyes. "My behavior was inexcusable. I was so consumed by my own perceived inconvenience that I was utterly disrespectful and inconsiderate. And to think that you then presided over my appeal." Her voice choked with emotion. I remained silent for a moment, allowing Karen to fully express her remorse. The afternoon sun cast long shadows across the quiet street, the weight of Karen's belated apology hanging in the air. "Ms. Miller," I said finally, my voice gentle but firm, "while your behavior in the bookstore was certainly regrettable, my duty as Chief Justice is to review all cases impartially, based solely on the legal merits presented. My personal interactions outside of the courtroom have no bearing on my judicial decisions." Karen nodded slowly, wiping a tear from her cheek. "I understand that, Your Honor, but I still felt it was imperative to offer my sincerest apologies. My actions were a reflection of a regrettable lack of consideration for others." A small, genuine smile finally touched my lips. "Thank you for coming, Ms. Miller. I appreciate your sincerity." The unexpected encounter on my doorstep marked a profound turning point for Karen Miller. The sheer, almost unbelievable irony of her rudeness, having been directed at the very person who held such significant authority over her legal fate, served as a potent and unforgettable lesson. In the weeks and months that followed, a remarkable transformation unfolded in Karen's demeanor and her interactions with the Willow Creek Estates community. The constant stream of petty complaints and self-righteous pronouncements ceased entirely. She became an active and surprisingly helpful member of the neighborhood, volunteering for community events and offering assistance to her neighbors with genuine warmth and without any expectation of praise. She even cultivated an unlikely friendship with Mrs. Davison, the long-suffering recipient of her past horticultural criticisms. The two women could often be seen chatting animatedly in their front yards, sharing gardening tips and neighborhood news with genuine camaraderie. The garden gnomes remained in their slightly too tall positions. The beige trim continued its subtle rebellion against the community's aesthetic uniformity, and the ceramic frog maintained its perch on the porch railing. It was as if the Supreme Court's ruling, in the subsequent, deeply embarrassing realization of who Chief Justice Alex truly was, had somehow liberated Karen from the self-imposed prison of her own rigid expectations and judgmental nature. The staggering irony of her own rudeness, having been directed at the very person who held such power over her legal fate, forced her to confront her own arrogance and to recognize the inherent worth and dignity of every individual, regardless of their perceived status or their participation in a private phone call in a bookstore. For my part, I never publicly acknowledged my prior encounter with Karen Miller. In court and in my written opinions, I maintained the strict impartiality that defined my judicial career. However, the memory of the entitled woman in the bookstore served as a quiet, personal reminder of the unpredictable ways in which human interactions could intersect with the solemn pursuit of justice and the profound impact that even seemingly insignificant moments could have. The resolution of Miller vs. Willow Creek Estates was more than just a legal precedent. It was a catalyst for unexpected personal growth and a subtle shift in the social dynamics of a small suburban community. And at the heart of that change was a HOA Karen who, through a humbling and ironic twist of fate, finally learned the enduring value of respect, consideration, and perhaps most importantly, thinking twice before telling someone to stop talking.